Y'all hear me?
Yes.
Good, good.
This law firm has the pleasure of serving as the town attorney for the town of Fort Myers Beach. There is a published agenda today where we have filed 8 cases. However, since the filing, we have been able to work with property owners and would like to go ahead and continue 4 of those cases. So today we would like to present to you 4 cases. I have spoken with representatives who are present in the audience for all of the 4 cases.
Okay, which ones are we going to hear today?
The ones we're going to hear today on the agenda is agenda item A, which is 1035 Estero Boulevard, KLC Surf LLC, La Ola. Also, agenda item B, which is 1821 Estero Boulevard, Estero Boulevard Corp. And Stephen Larson doing business as Sun and Fun. Agenda item C, 2815 Estero Boulevard, Hempstead Associates LLC, and 81 Miramar Street, Patricia Smith, trustee. Your Honor, this is our first time working with you digitally, I guess is one way to say it. So I apologize if we hit some little speed humps today. But what we've tried to do is to send you an electronic copy of what our hearing exhibits are. We did file exhibits when we initially filed the case, but we've changed them a little bit, not a lot. We have provided print copies, or will be in the process of providing print copies to the representatives who are present. And you'll have your electronic version of it as well.
Okay.
I don't know your policy as far as swearing in witnesses for testimony, if you wanted to do that at the beginning or for each case. What is your pleasure?
Usually I'll swear everyone in at once. Do we have everyone, all the parties that are going to participate, in the 4 reductions here? Not everyone, perhaps that knows who I am. My name is John Van Lanningham. I'm going to be serving as the town's code compliance special magistrate in these hearings. I'm located in Tallahassee, and so we're conducting the hearings by this video set up through Zoom. I'm assuming that we'll call the cases in the order that you've listed them, A through D.
Yes, Your Honor. Also, the cases that we're continuing, for the record, if we can identify those for you.
Sure.
Because we do have some people in the audience that came just in case. To be continued is agenda item D, which is 4900 Estero Boulevard, owned by Island Towers Condo Association, continued to the February 4th hearing. Again, we are hoping that we can come to compliance and be able to advise you of that at that hearing. Agenda item E, which is 1249 Estero Boulevard, owned by 1249 Estero Adventures LLC, continued to February the 4th. Agenda item F, 2450 Estero Boulevard, owned by 2450 Estero Boulevard LLC, continued to February the 4th. And 406 Estero Boulevard, owned by Windward Passage Resort Condo, continued to February the 4th.
All right, very good. Are there any other preliminary matters that we ought to take up before we start hearing the cases?
I don't think so, Your Honor. Or 004407 on the 19th day of November. And this case involves property that's located on the 19th day of November. And this case involves property that's located at 1035 Estero Boulevard. So I would like to go ahead and make some preliminary remarks regarding the nature of the complaint that precipitated the initiation for preservation in the record regarding the case.
Let me just, before you do that, who's here on behalf of the respondent, 1035 Estero Boulevard?
Good morning, Your Honor. For the record, Amy Toubeau with Retzel and Andrus. I represent the respondents.
How do you spell your last name?
Good question. T as in Tom, H, I, B as in boy, A, U, T as in Tom.
Got it. All right. And do you have anyone here who's your client rep?
So for the property owner respondent, KLC Surf LLC, we have Chris Primo, who is the manager of that entity. And then for the operator, the lessee of the restaurant, which is TEH4, we have Tom Houghton, who is the manager of that entity as well and can speak to the operational and development aspects factually as needed.
All right, very good. Well, let me hear from the town and then we'll come back to you.
Thank you, Your Honor.
So, Your Honor, hopefully you've received our digital copy of the exhibits that we want to present to you today. We are going to attempt to put them on the screens that we have in our hearing room. And I'm going to walk through those exhibits as well as our code enforcement officer, Officer Yazzo, during his presentation. So the first exhibit is Exhibit A, and please bear with me. This kind of establishes the complainant in these code enforcement cases, as well as the reasons why we're here doing this. It contains our first exhibit, first item in Exhibit A is a letter from FEMA, which is dated July the 19th. Can we go to the next one? There we go. Okay. And this letter was addressed to Andy Hyatt, who is the town manager of Fort Myers Beach. The letter includes a summary of the town's noncompliance with its minimum floodplain standards and codes. Specific to this case is there is a reference on page 3, paragraph 2B, which requires the town to provide a plan for remedying any of the identified violations. So attached to that letter of July the 19th is the Town of Fort Myers Beach Post-Disaster Compliance Status Update Report from FEMA. And this identifies some compliance issues that the town has run into. Page 2 of the report specifically says that there was a failure in the town's permitting system, which allowed the use of temporary non-compliant structures including shipping containers and trailers / food trucks. And then the statement in the report is followed by a list of town of Fort Myers Beach citations. Further down on the page in paragraph 3, it says that non-compliant structures, parentheses, containers, and temporary structures that have been placed in the coastal high hazard zone, the VE zone, and the coastal A zone. Please provide a plan to remove these structures or bring the non-compliant structures or non-compliant additions into compliance, and confirmation that the town has stopped issuing permits for this type of non-compliant development. The letter of July the 19th of 2024 from FEMA to the town also included a deadline of November 18th for the town to remedy these violations brought to its attention. Shortly after the July 19th, the town council directed the town manager to stop issuing any type of permit for this type of non-compliant development because of the benefits that some of these businesses that operate out of these shipping containers and food trucks present to the residents. The town sent a letter to FEMA asking for its compliance date to be extended to June 2025. And I believe that letter is dated November the 1st with a video link embedded in that letter. Guys, you guys got to go up a little bit more. There we go. Is that, yeah.
That's the July 19th letter.
The July 19th. We're looking for a November 1st letter, but it is in the packet. So I'll proceed. But the letter also included a link to a video that was actually prepared by the respondent in this first case to show how quickly some of these businesses that are operating in these non-compliant structures could actually relocate in the event of a declaration of a hurricane warning from the area. I believe on the 12th, yeah, that's the letter. On the 12th of November, FEMA responded with another letter saying that it was not authorized to extend the existence of any non-compliant development, and further added that the purpose of these regulations is to protect lives and property in the special flood hazard area. FEMA went on to say that these non-compliant structures are in the most at-risk area, the VE zone, also known as the coastal high hazard area, which received a 14-foot storm surge during Hurricane Ian. So allowing these structures to remain in place presents a hazard to residents and businesses in the event of another storm, as demonstrated by Hurricanes Helene and Milton. So having received that letter, the town diligently worked with the property owners that had these non-compliant structures, and some actually in the aftermath of Hurricane Milton and Hurricane Helene were able to remove and from the property. Recently, on December the 16th, the town directed the town manager to rescind any remaining temporary use permits that were still out there. And again, the town continues to work with the property owners who have these non-compliant structures on their property to have them voluntarily removed. And as you see, based on the removal of 4 of the 8 from our agenda, we do have a good dialogue with our residents and businesses who have these structures there. However, we are compelled to bring some of them to you in the event that we're not able to reach any type of resolution. So at the end, we will summarize the various exhibits that we are presenting to you and ask that they all be put into the record. So providing you testimony today regarding the actual violation is Officer Thomas Yazzo, who will introduce himself, as well as Carl Thomas, who will provide you with their credentials and their case.
Did you want to call those witnesses at this time?
Yes, sir. I would first call Officer Yazzo.
Good morning.
Morning, Your Honor.
Let me get your full name again for the record.
My full name is Thomas, common spelling. Last name is Yazzo, Y-O-Z-Z-O.
Mr. Yazzo, you may proceed.
Good morning, Your Honor. My name is Officer Thomas Yazzo. I'm a Code Compliance Officer and the Compliance and Security Manager with the Town of Fort Myers Beach. As a manager for the Compliance Security Department, I am responsible for day-to-day operation of the Town of Fort Myers Beach Code Enforcement Department, and I supervise 4 code compliance officers. I review all code enforcement cases with them and have access to all available code enforcement files. In addition to this, since July of 2024, I have been personally involved with the town's efforts to come into compliance with the floodplain regulations identified by FEMA, which are incorporated into the town code of ordinances. I've been sworn in and will provide testimony and documentation regarding the violation in this case. During my testimony, I will periodically refer to exhibits in the agenda materials and request that these materials be admitted into evidence and included as part of our record for this case. Again, this is Fort Myers Beach Code Enforcement Case number 2024-0915, which is also identified as DOAH case number 24-004407. The subject property is located at 1035 Estero Boulevard, Fort Myers Beach, Florida, 33931. On September 19th, 2024, I observed a shipping container on the subject property, which I determined to be a non-compliant structure based on current floodplain regulations, inclusive of design codes required in special hazard areas as defined in Section 6-494 of Fort Myers Beach Code of Ordinances. The subject property is located in a coastal A, partially as identified in the latest floodplain map, and requires the structures to have a base flood elevation of 13 feet above sea level. I observed that the shipping container was not elevated, and to the best of my knowledge did not have the engineered plans for pilings and infrastructure. I then consulted with the Fort Myers Beach floodplain manager, Carl Thomas, who confirmed to me that the shipping container on the subject property was a non-compliant structure. Based on my observation and in violation of Section 6-501 and 6-52 on September 24th, 2024, and I sent a copy of it by certified mail return receipt to the address of record, specifically 2327 Nursery Road, Clearwater, Florida, 33764. Posted a copy of notice violation at the subject property and at Town Hall located at 2731 Oak Street, Fort Myers Beach, Florida, 33931. A copy of the affidavit of notice and posting evidence of ownership is labeled Exhibit B. I would like to also include in the record, as well as affidavit of notice and posting, notice of the information about the case is also displayed on the Town of Fort Myers Beach website, easily located under the public notices. The respondent is present at today's hearing, is represented by Amy Thibault, an attorney for Roxland Andres. I did take photos to document the violation. I observed on September 19, 2024, they're clearly presented in Exhibit C. They contain true and accurate and unaltered copies of these photographs during my initial inspection on September 19, 2024. The photographs show that the shipping container is not elevated to 13 feet above sea level. Additionally, the photographs show there are 3 shipping containers. Additionally, the photographs show that there are photographs showing permanent attached ramp and railings and decks and stairs. In my notice of violation, I gave LKC Surf LLC 30 days from September 19th to remove the shipping container from the property or to otherwise come into compliance with the town codes. I directed a re-inspection of the subject property occurred on November 18, 2024 by Officer Danielle Batt, who I supervised, and she informed me that the shipping container remained on the subject property in the same condition as shown on the photographs I previously took, which were part of the case file. I directed Officer Bat to prepare an affidavit of noncompliance, and a copy of which is included in Exhibit D. The property owner received a letter revoking and rescinding its permit on December 19th, 2024, a copy of which is also included in the file in Exhibit F and all agenda materials. As a result of the property owner's failure to remove the shipping containers or to bring the subject property into compliance with Section 6-501 and 6-525 of the town's land development code, as identified in the notice of violation, the property owner was provided with a notice of today's code enforcement hearing as shown in Exhibit G, with the affidavit of notice and posting of today's hearing. In advance of today's hearing, I re-inspected the property yesterday, January 6, 2025, and took photographs again of the shipping containers with floodplain manager Carl Thomas present, which remains on the subject property in the same condition as I initially observed September 19, 2024. I'd like to add those photographs into the record, which was sent to you via email as Exhibit H. At this time, Your Honor, I'd like to ask floodplain manager Carl Thomas to provide you with additional information regarding the town's code sections and ASCE 24-14 and what is needed for the shipping container on the subject property to obtain compliance with the town's code. Thank you.
Let me just ask you, there's some new photographs. You said they were sent to me?
Yes, sir.
Your Honor, they were sent to your assistant, Janine.
As to why this is a violation.
Let's do this before we go to the next witness. Ms. Scoopers, do you have any questions for Officer Yazzo? Anything you wanted to ask him?
No, Your Honor, not at this time. Your Honor, I believe that, this was our first time working with DOAH. So we do have a set of the exhibits that the clerk mentioned. They're a little bit different than what is currently filed with DOAH. So that may be the reason why you're not able to see these pictures yet.
I'll get them. If they have them, they'll get them. Let me ask Ms. Tebow if you have any questions for cross-examination here for this witness.
My only question for Officer Yazzo at this time would be to confirm that you are finding this to be in violation due to failure to meet base flood or design flood?
That's correct.
No further questions. Thank you.
Let me just ask you, while you're standing up there, Ms. Tebow, before we hear from the next witness, oftentimes in these code cases, I do it for a lot of jurisdictions. First time I've done it for the town here. But just so I get a sense of what the disputes are you all disputing the alleged violations, or do you have other issues to raise, like length of time for compliance and that sort of thing?
Your Honor, both would be present in this case. I have a presentation that I will go through after the town completes its presentation, where I'll set forth our argument as to why this is not a violation of the town code. But, alternatively, and in the interest of working with the town, we do have a couple of alternate requests that we will propose at that time. Time to, should you find that this is a violation, we would ask for extended time to abate and, consideration of a couple of other issues at that point as well, a couple of affirmative defenses.
All right, we'll hear those arguments, and let's go ahead and finish up the town's case. We'll come back to that.
Thank you, Your Honor.
And I believe we can take the next witness.
Good morning, Your Honor. My name is Carl Thomas, and I am the floodplain manager for the town of Fort Myers Beach. I've been the floodplain manager for the town since, I have been a floodplain manager since 2011, and I received my certification from the Association of State Floodplain Managers in April of 2011. With my certification, I've worked with several local governments concerning flood regulations, such as those in effect in the town of Fort Myers Beach. And since May of 2024, I've been specifically working with town staff and representatives from the Federal Emergency Management Agency to meet the requirements of FEMA's post-disaster compliance report for Hurricane Ian, included in Exhibit A of the agenda materials. I am here to provide testimony regarding the noncompliance of the subject property, which is located in a high-risk flood zone. In September of 2024, I had conversations with Officer Tom Yazzo regarding his concerns that shipping containers on the subject property were in violation of the town's floodplain regulations as claimed by FEMA in its compliance report. I explained the criteria that would need to be satisfied in compliance with Chapter 6, Division 10, Section 6-501 and 6-525 of the town's Land Development Code. A copy of Sections 6-501 and 6-525 and an excerpt from ASCE 24-14 are included in Exhibit E of the agenda materials. In summary, I explained to Officer Yazzo that Sections 6-501 states that any structure located in a flood zone, even if they are exempt from permitting per Florida Building Code, must be designed in accordance with the American Society of Civil Engineers, ASCE for short, Standard 24-14 for flood-resistant design and construction, where compliance includes elevating the structure to the base flood elevation plus 1 foot, anchoring the structure to remain in place during flood conditions, or having flood openings or breakaway walls that allow unobstructed passage of flood waters through the structure. Non-compliance with flood regulations not only increase the vulnerability of the structure itself, but also pose significant risk to public safety, neighboring properties, and the environment. Additionally, it jeopardizes the community's participation in the National Flood Insurance Program, potentially increasing insurance premiums for all residents. Subsequent to my September conversations with Officer Yazzo, I accompanied him on a site visit to the subject property during the second week in December, and most recently, another site visit yesterday, January 6, 2025. Again, we discussed the requirements of compliance under the town's floodplain regulations. For the purposes of illustration of the hazard non-compliant structures can cause, I have a photograph I received from Officer Yazzo taken after Hurricane Milton by Andrew Hyatt, our town manager. And what it shows is evidence of a non-compliant structure similar to what we're discussing today that was displaced during the storm and created a hazard to the residents of the town. The non-compliant structure ended up in the area of North Estero Boulevard. We have no evidence where the shipping container was initially located or of its owner. In my opinion, similar displacement is possible with non-compliant structures, such as what we're discussing today, and the subject property, depending on the strength of the flood event. In summary, it is my opinion that the shipping container located on the subject property is non-compliant with the cited town's floodplain ordinances, and I would like to ask the judge to include a copy of ASCE 24-14 and Mr. Hyatt's photograph in record for this case. Thank you.
All right, thank you. And let me ask Ms. Cooper, if you have any questions for the witness?
I do, Your Honor. Mr. Thomas, can you tell us a little bit more about the photograph? So you testified that it came through the town manager, but did the town manager actually take that photograph, or was it perhaps the director of public works?
Photo came from the town manager, but I believe the photo was taken by the director of public works. Jeffrey Cole.
Thank you.
Any cross-examination, Mr. Duvall?
None at this time. Thank you.
All right, thank you.
So, Your Honor, based on the sworn testimony and the evidence that the town has presented to you, including the exhibits that are attached to the hearing exhibit package that should have been transmitted to you today, the town is going to be asking for a finding of a violation of section 6-501, 6-525 of the Land Development Code, and ASCE 24-14 as of January the 6th, which is based on the most recent photographs that are in your agenda packet, requiring that the property owner come into compliance with the town code or removal of the shipping container within a reasonable period of time that we would look to your guidance to establish as the compliance date. Also, a fine of $250 per day in the event that there is no compliance or the non-compliant structure has not been removed by your compliance date. An administrative fee of $250 to cover our expenses. And lastly, authorizing the town to abate the violation by the removal of the shipping container if compliance is not obtained by March the 1st, with any expenses that are incurred by the town to be paid by the property owner within 30 days. And if the town's expenses remain unpaid beyond the 30 days, the town would request certification of the amount owed to be imposed as a lien on the property. In your packet that was presented to you today, Your Honor, we have a proposed order.
And I do have those. They've been emailed to me. I haven't
Okay.
opened them up, but I see them there in the queue.
Great, and we have basically identified the various exhibits that should be in the packet before you. That it is our intent to have presented those to you, and that's it.
Is the town recommending March 1 of this year as the compliance date? You mentioned that.
No, we would request the authority to abate the violation on March the 1st. And that date is tied to the town's obligation to provide a status update to FEMA in April. So we would need a little bit of time to actually have it removed in the event they are not able to attain compliance.
All right. Okay, very good. Let me hear from Ms. Tebow.
Good morning, Your Honor. Again, for the record, Amy Tebow, Retzel and Andrus. I represent the respondents, and I have a quick presentation that I have prepared today to discuss this case.
All right, very good.
Maybe.
I'm sorry, the clicker, I'm having a little, oh, there we go. So as discussed already by Mr. Yazzo and Mr. Thomas and Ms. Stuparich, the property subject to the code case today is located at 1035 Estero Boulevard, and it contains approximately 0.17 acres. It is within the coastal A and VE zones, and it does consist of some development that has been discussed here today, including 2 modular shipping containers affixed to trailers, which has not been discussed to date. As well as decks, stairs, and ramps that are not structurally connected to the shipping containers and which were permitted separately. So they are structurally independent of the shipping containers, and the shipping containers are located on large trailers. I have some photos of those in a couple of slides that are easily removed from the property in the event of a storm. And quite frankly, that have been removed from the property ahead of Hurricane Milton, which again, we will discuss shortly. So the town has already gone through a lot of the history here and, some of the facts leading up to the current proceedings here today. But of course, on September 28th, 2022, Hurricane Ian made landfall right here on the island. And along with many, many other uses on the island, the pre-existing restaurant and bar was substantially damaged and has since been demolished. In November of 2022, the respondents applied for and obtained a temporary use permit to operate the restaurant on the site out of temporary containers and with a mobile food truck. And then in February 2023, that's when the permit applications for the deck, stairs, and ramps were filed, and those permits were subsequently issued by the town. It's pertinent to note that the development that is on the site has been approved not only by the town through various permits, it's also been approved by DBPR in conjunction with the mobile food vending license that is held by the lessee and operator of the site, as well as the COP, consumptive, not consumptive use permit, but the liquor license that is held by the operator for that site. And this configuration has also been approved by the Department of Health as well. And it has passed all of those inspections. But as Nancy noted, in this past summer, 2024, FEMA sent a demand to the town mandating removal of a variety of temporary structures, including the containers, which were lumped into that. In October of 2024, the respondents appealed to town council, and town council voted to send a letter to FEMA requesting permission to allow the containers on this property specifically to remain as they are. And as Ms. Stuprich mentioned, that letter does contain a hyperlink to a video that shows the evacuation operations for these containers, because again, they are on trailers. So they are simply removed ahead of a storm event. But in November of 2024, FEMA denied this request, and subsequently the town has been put into a probationary period for the NFIP program and as authorized under those regulations in the Code of Federal Regulations. And so they have, in conjunction with that probationary period, mandated that the town, of course, enforce what FEMA deems to be non-compliant structures and other, truly structures. So that is, again, why we are here today, just to reiterate what the town has already presented. And so these are photos of the trailers on which the shipping containers are stored. So, of course, this does not show the shipping containers on them, but there are a plethora of photographs of the site as developed that the town has already submitted, so we didn't want to be redundant. But we did want to include these photos just to show you. These are very large gooseneck trailers, and the shipping containers are affixed to these, and these trailers are located on the site. So the shipping containers actually are not affixed to the ground or to any type of permanent or semi-permanent foundation. They are affixed to these trailers. And as I mentioned earlier, ahead of Hurricane Milton, which made landfall in October on a Wednesday, a mandatory evacuation was issued for this property on that preceding Sunday at about 4 p.m. By 11 a.m. the next morning, that Monday, both of these shipping containers on their trailers had been removed from the site, taken off island and upland, and secured in a location where the containers and the trailers themselves were safe from the storm and the impacts thereof, and were subsequently brought back onto the site safe and sound and have continued to operate since then. So, as the town has already discussed, they are alleging violations of Section 6-501 of their Land Development Code, which requires compliance with the American Society of Civil Engineers Publication 24-14. And this is specific to buildings that are not regulated by the Florida Building Code. The second section of the Land Development Code that the town alleges has been violated is Section 6-525, which imposes requirements for development that is not explicitly regulated elsewhere in the code. And then, of course, Mr. Thomas has already discussed ASCE 24-14 and has requested that that publication is entered into the record. But that is a publication, again, from the American Society of Civil Engineers, and it pertains to structures. And the reason that I keep bringing up structures is because, as we will get into a bit more in here, this configuration with these shipping containers on the trailers, they're not structures within the meaning of FEMA's regulations. And therefore, well, I'll get into that in just a moment. But again, the summary of the argument is that the containers do not violate the regulations adopted for the National Floodplain Insurance Program in 44 CFR sections 59 et sec. Specifically, there are some definitions in 44 CFR 59, but a lot of the requirements as far as, requiring structures to be at base flood or design flood, regulating recreational vehicles, regulating how this type of development can be undertaken is located in 44 CFR section 60. So we would ask that you do take judicial notice of those sections of the CFR. But further, as we will demonstrate, the containers are not in violation of the town's land development code either. Further, finding that the containers are a violation would implicate due process, because the government can't penalize conduct that is not expressly prohibited. And as we will get into, this configuration is not expressly prohibited by either the Code of Federal Regulations or the town's land development code. Further, we assert that even if this was a violation, the town would be equitably stopped from asserting these violations at this point. And finally, it's really imperative to mention the practical implications of this case. The Loyola Surfside Restaurant and Bar is a mainstay on the island, and not only would there be hardship on the property owner and the lessee, who have relied in good faith that the approvals they have received, not just from the town, but also from the state on multiple levels, demonstrated that this configuration is appropriate, acceptable, and within the confines of the law. But there's also a plethora of folks that rely on the operation of this restaurant for their own livelihoods: the employees, the entertainers, and of course, the town itself is struggling to rebuild after Hurricane Ian. It has been, quite frankly, a brutal process for everybody involved, and it's not for lack of the town's good faith efforts, but by eliminating some of the few uses, commercial uses, and specifically restaurants that are back up and running on the island in the aftermath of Hurricane Ian, which made landfall almost 2.5 years ago. It just further puts the town a step backward. So with that, I will get into the Code of Federal Regulations. So specifically, the Code of Federal Regulations defines structures as a building that is affixed to a permanent site, or a manufactured home that is affixed to a permanent foundation, or a travel trailer that is affixed to a permanent foundation. So the shipping containers on the trailers, as they are configured now on the site, don't actually meet any of the 3 different definitions of a structure set forth in the Code of Federal Regulations. And the definition, at the very end of the definition, it states, for the latter purpose, structure does not mean a recreational vehicle or a park trailer or other similar vehicle except as described in paragraph 3 of this definition, which essentially is a travel trailer that has been affixed to a permanent foundation. That type of vehicle must meet base flood and design flood. Well, base flood, because it's residential. But this configuration also does not exactly fit into the definition of a recreational vehicle either. These trailers, as you can tell, are very heavy duty trailers. So they are not towable by a light duty pickup truck, but they are towable by a heavy duty pickup truck, which is something that the respondents possess and have demonstrated that they are able to utilize to remove these containers and the trailers from the site quickly and efficiently ahead of a storm. Further, these are also not recreational vehicles because they're not temporary living quarters for recreational camping, travel, or seasonal use. These are truly, this configuration is an innovative configuration, and it's not one that the Code of Federal Regulations expressly contemplates. And the reason that I bring this up is because, for example, a recreational vehicle can meet FEMA floodplain requirements one of three ways. The first is that it can be affixed to a permanent foundation, as we've already discussed. And if it is, and it meets those permanent foundation requirements that are set forth in the Code of Federal Regulations and ASCE 24-14 and all other requirements, then that is acceptable. But that's not the only way that a recreational vehicle is acceptable. A recreational vehicle that's on site for less than 180 days is also acceptable. It need not be at base flood elevation. Similarly, a recreational vehicle that is highway ready, that is hooked up to quick disconnect utilities, and that is licensed for highway use is also acceptable under the FEMA regulations. And the reason that I bring this up is because, again, these containers on the trailers don't fit neatly into the definition of a structure, and they're not recreational vehicles either. But as you will see, it meets the spirit and intent of the FEMA regulations, ASCE 24-14 and the Land Development Code. So here, structures where recreational vehicles can be compliant with FEMA regulations, via one of the three ways that I've just discussed, structures are handled differently. Structures are required to meet the base flood elevation, and depending on the zone that they're in, they have certain foundation requirements, certain types of pilings they need to use, certain types of materials. And all of that, again, is governed by, primarily for a site like this, 44 CFR 60.3, and also ASCE 24-14. But a lot of what those requirements also state is that, for example, if certain improvements can be removed from the property with at least 12 hours notice of the storm, that can comply with ASCE 24-14. Again, going back to the RVs, removing RVs from a site that that is in the path of a storm, where the RV maybe wasn't located at or above base flood, but that leaves ahead of a storm, that is also compliant. There's no penalty for that. So here, we don't have shipping containers that are permanently affixed to a foundation and just haven't met base flood. They are transportable, and as we've discussed prior, and I'm sure Tom Houghton, who is the manager of the lessee entity, will discuss later on if you have any questions. He can explain to you exactly how this evacuation process has been planned and has actually been undertaken, executed, and how it has succeeded. So we are simply here to state that, one, the configuration that we have, while we can't speak for every other shipping container on the island or temporary structure or whatever, here, this type of innovative development hasn't really been contemplated by the Code of Federal Regulations. And that's not unusual. I mean, we see innovation in a lot of industries, and the law is often slow to catch up on that. But the particular conduct that has been undertaken by the respondents is not actually in violation of any of the FEMA regulations. So this slide just, again, reiterates that. Now, getting into the case at hand, the containers don't violate the LDC. So the intent of the floodplain regulations, again, is to protect the public health, safety, and welfare, protect life, protect property. And as you will see, the configuration on this particular site does just that. The first alleged violation, of course, is of Section 6-501, which states that pursuant to Section 6-443 of the Land Development Code, buildings, structures, and facilities that are exempt from the Florida Building Code must meet the requirements of ASCE 24-14. So Section 6-443 of the Land Development Code lists a variety of structures to which this applies. They don't include the shipping containers themselves. So that's, I would just say, pertinent to note. I would argue that 6-501 Land Development Code actually does not apply to this property for that reason. So further, the containers are not actually exempt from the Florida Building Code. They are regulated as manufactured structures, which require insignias, and this is in conformance with with sections 553.35 to 553.42 of the Florida statutes, which provide the general Florida Building Code requirements for manufactured buildings and structures and other facilities like these shipping containers. But for this reason, Section 6-501 Land Development Code does not actually apply to these containers. More importantly, Section 6-525, which is the second provision of the code that the town alleges has been violated, actually does apply to this, but we are in conformance with this requirement. So this is sort of a catch-all provision that states, general requirements for all other development that hasn't been explicitly contemplated in the town's floodplain regulations. So the first criteria is that it must be located and constructed to minimize flood damage. It must be anchored to prevent flotation, collapse, or lateral movement resulting from hydrostatic loads. It must be constructed of flood damage resistant materials, and it must have mechanical, plumbing, and electrical systems above the design flood elevation or that meet the requirements of ASCE 24. So it's important to note that ASCE 24-14, Part 7 or Chapter 7, governs the type of facilities that are contemplated in subsection 4 of 6-525. So specifically, the first general provision in section 7.1 is that either these utilities and equipment must be located above the minimum elevation, either base flood or design flood, or they must be specifically allowed below the minimum elevation and designed, constructed, and installed to prevent floodwaters, including any backflow through the system, from entering or accumulating within the components. So again, as I noted before, ASCE 24-14 really only applies to structures, but in the spirit of and intent of trying to meet these regulations, there is no evidence that the utilities, the mechanical, plumbing, and electrical facilities are actually not compliant with ASCE 24-14. So that meets that fourth criterion. As we've demonstrated, the containers have been designed and located to minimize flood damage. They've been designed in a way where, yes, they are located in a high-risk coastal area, but they are designed to be transportable. And we are fortunate to live in an area where, while we do get major storm events and major flood events, we typically have ample notice. And therefore, this design and location of the containers as they are configured on the trailers meets that first criterion set forth in 6-525. They are acceptable, and then when there is a storm event coming, they can be easily removed and quickly removed. As far as the second criterion, the containers are anchored and mobile to trailers, so they are there to ensure safety when located on the subject property, but they are transportable and have actually been transported before storm events, and then again, of course, after storm event coming back onto the site. And the containers are made of flood-resistant materials, and again, the plumbing, mechanical, and electrical facilities are, for all intents and purposes, appear to be compliant with ASCE 24-14. So for that reason, this is really actually not a violation of the town's land development code. And we would respectfully assert that, or we would respectfully request that you find that there is not a violation of those sections. And I will add that the law is required to provide fair warning of prohibited conduct. So the property owner and the lessee have taken every step in good faith to try to bring this restaurant and bar back to the island They've done it in a way where they have worked with a variety of professionals and consultants. They've applied for all of the requisite permits. They obtained those permits. They brought the trailers to the site. They brought the shipping containers to the site. They built the accessory decking and stairs and ramps, all under valid permits. And there was no issue with this for close to 2 years until FEMA came into the picture and argued that these are structures, but they're not. And now we're in a position where we are arguing nuanced, nuanced technical requirements here. But the reality is that multiple agencies have found that this configuration complies with all applicable rules. It was just this past summer. And I don't even want to say that FEMA necessarily was targeting this particular site, but I think that there are a lot of temporary structures on the island that potentially do create issues that harm the public health, safety, and welfare. These don't. And to penalize them when they are not expressly prohibited would be violative of due process. So again, going back to what we've already discussed, the Code of Federal Regulations explicitly exempts RVs and similar conveyances from the definition of the structure. And those are not required to meet base flood or design flood. And the containers do comply with 6-525 and therefore are permitted. So to penalize a property owner and operator for conduct that is not expressly prohibited, again, it violates due process. Further, there is the issue with equitable estoppel. So a property owner and lessee have relied in good faith upon the acts of the town, who has issued several permits for this site in the aftermath of Hurricane Ian that have all led to the existing development of the site that is now being alleged to be in violation. And they made substantial changes in their position. They bought these trailers and these containers. They've gone through the cost and time and effort of permitting them, and the cost and the time of effort of permitting other accessory structures that are structurally independent to try to meet, all requirements that have been adopted by both the town and the federal government and the state for that matter. And they incurred really extensive obligations and expenses at this point that it would be highly inequitable and unjust to destroy that right by simply mandating that these shipping containers that have there's very, very little risk associated with the configuration of the site as it stands currently. And to revoke that right would be highly, highly unjust. And again, as I discussed earlier, we can't talk about this case without talking about the implications and the substantial hardship that would result from requiring the removal of the shipping containers. That would be requiring the removal of an entire restaurant operation. And not only that, it would be doing so in the midst of the busy season where they make a lot of, I don't know exactly what percentage of their revenues are obtained during season, but a lot of the revenue is obtained between Thanksgiving and Memorial Day weekend when snowbirds and other folks come into town to visit. Not only that, during this time, this is our dry season. So we are not in hurricane season. The risk of storms is far reduced between now and June. And there are many, many people that depend on this restaurant for their livelihoods. To simply say that this is a violation is pulling the rug out from under not just the property owner and the lessee, but also all of the employees, all of the entertainers, all of the people who in one way or another depend on DOAH for their and their families' livelihoods. So at the very least, at an absolute minimum, if you do find that this is a violation, we would ask that you would at least allow the restaurant to operate as it is configured now through Memorial Day weekend, because again, this is our dry season, very little risk of storms during this time. a lot of good can be gained for all of these folks that do financially depend on the OLA. And it would also give folks enough time to plan for the next step. You know, how are they going to maintain that income stream? Should you find that this is a violation and you mandate removal of these structures? So that was a lot. And with that, please let me know if you have any questions.
Let me ask you a question or two, and then you have a couple of witnesses, correct?
Yes, I have Tom Houghton here with me, as well as Chris Primo, who is the manager of the landlord entity KLC Surf LLC.
In terms of the argument you're making, that this configuration of shipping container and trailer essentially doesn't meet certain definitions. It's not a structure, you argue. And it's also not, I guess, at least not strictly speaking, an RV, right?
Right.
I mean, it's neither of those,
Mm-hmm.
as you argue, according to your argument. Can you tell me what affirmatively it is? If it's not an RV and it's not a structure, what is this configuration? What would you, does it have a label, or what would you call it affirmatively?
That's a really good question. I'm not exactly sure that I would have a name for it. Quite frankly, this is the first time I've worked on a project that has this type of configuration. So this is fairly new to me. And to my knowledge, I don't really know of any other sites that have this type of configuration. So it plays into why I mentioned earlier that this is an innovative concept. It is structurally sound in its configuration on the property as it is on the trailers, but it's also very easily transportable. I don't know exactly what I would call it. I would call it maybe like a mobile bar and restaurant. Not to say that they're trying to just pick this up and take it to food truck parks, but it's truly a kind of a semi-permanent mobile configuration that allows for them to operate before, you know, permitting a full true structure that has a permanent foundation, all of the, you know, pilings that are required in a coastal A zone.
Is the key distinction here, and it's been a point of emphasis in your argument, the trailers? I guess these is your description of these trailers at issue in this case are that they're sitting on these containers. They're sitting on these breaking trailers. The trailers have wheels, and apparently you can hook up to a truck and move them off site relatively quickly. And so I take it that as they sit there today, they're sitting on these trailers. Is that right?
That's correct.
If the trailers weren't there and the containers were sitting on the ground without the trailers, would you concede that it would be a structure then, and so it wouldn't be an RV?
Absolutely, yeah. Because for the structures to be located on the site without the trailers, they would have to be affixed then to the site via some type of permanent foundation, tie downs. I'm not a contractor, so I'm not an expert, but yes, typically shipping containers are affixed to the site via some type of foundation.
And other than the trailer aspect, which I think you noted at the outset was something that hadn't been emphasized in the town's presentation, it doesn't seem to me like there's any real dispute about the facts, and the trailer might not be disputed either. The town just hasn't focused on it yet. Maybe they will in response to your argument. But other than the issue of the trailer, you don't seem to be disputing any of the facts. Your argument is really more of a legal argument in terms of, well, if we look at this situation, does it meet the definition of structure here? Does it meet the definition of the RV there? It's a legal argument more than a factual one. Would that be fair to say?
That is correct, Your Honor.
All right. Let me call you. I'm just going to ask a very quick question to the town. Let me address Ms. Stuper very quickly. Does the town dispute the factual existence of the trailer? I don't know if that's a fact dispute or not. It seems to be, or not seems to be, is obviously important to the respondent's argument. Is there a disputed fact about whether these containers are sitting on a trailer? I'm not asking at the moment whether that's legally relevant. Obviously, you'll have an argument on that, but is that in dispute or not?
Yes, I believe it is, Your Honor. And the basis for that is the trailers that these structures, non-compliant structures, allegedly sit on are not visible. And the property owner, if in fact that the non-compliant structure has been sitting on these trailers, they knew back in July for certainty that that could have been disclosed to the town, and it never was. So we do object to the inclusion of the photograph. The photograph itself has not really been authenticated. It's part of argument, and the property owner's attorney, she makes very good arguments, but that is argument and not competent substantial evidence. As far as the legal question concerning the interpretation of structure and RV, again, Ms. Toubeau, she recognized that she's really not an expert. However, you do have evidence before you, expert testimony from Carl Thomas, who is the town's floodplain manager, as well as documented evidence from FEMA that these are violations. And Mr. Thomas, as well as FEMA, they deal with floodplain regulations on a day-to-day basis, not in an isolated incident in a code enforcement case. As far as equitable estoppel, I don't think that that issue is really before you. The permit that was issued to them that they're referring to was issued right after, as the town was trying to come back after Hurricane Ian. And there were a number of those permits that were issued in error, which FEMA brought to our attention. And we have since ceased issuing those permits. We did not issue any for Milton or for Hurricane Helene. And we have also now affirmatively revoked those permits. I would, if I may, I would like to defer to Mr. Thomas as well, if he wanted to address some of the interpretation questions or issues that Ms. Toubeau argued into the record.
Let's do this way, because I think Mr. Bell has some additional witnesses to present and respond in this case. Then we can come back to the town for a rebuttal presentation if you wanted to put that evidence on. I just wanted to get a clarification on the trailer issue. And if I understand you correctly, Ms. Goodrich, the town is, you're telling me that the town disputes the existence of the trailers because you haven't seen them. Is that, would that be fair to say? You haven't seen them, or the inspectors or officers haven't
Yeah, I would need to,
told of their existence?
Your Honor, I would need to ask Mr. Yazzo to make, I personally did not go out and visit them, but the photographs that we did put into evidence, I don't think that they're visible. May I defer to Officer Yazzo?
Your Honor, with the visibility that we have,
Sure.
with the visibility that we have, with the skirting, the decking and stuff, the other accessory structures are built around it. You can't tell the trailer's there. I had no idea the trailer was there. We'd probably be in a different situation dealing with this case if I had known they were there. But we can go forward with the respondent with that in mind as well.
All right, we'll come back then to the town if you might want to present some additional evidence. Let me go ahead and let Ms. Thibault complete the respondent's case.
Yeah.
That's what this is.
Yeah, and I just quickly want to mention a couple of things. So the photos of the trailers that I pulled are actually from the permitting file for the initial temporary use permit that was obtained in November of 2022. So I can call Mr. Tom Houghton up here to discuss the authenticity of those photographs and the existence of the trailers and some of these other issues. So
All right.
Good morning, Your Honor.
Good morning. You have your name, please?
My name is Thomas Houghton,
And how do you spell your last name?
Houghton.
All right, Mr. Houghton. And Mr. Thibault, do you have questions for the witness? You want to just go ahead and examine him?
thanks, Mr. Houghton. So to confirm, the photographs of the trailers that were provided in my presentation Can you confirm where those photographs came from?
Yes, the trailer is actually originated, a friend of mine owns a trucking company, and so the pictures were taken snow, there was still snow in the photographs. My friend drove those down from up north, after we had, worked out I guess, a compliance plan with the town. The shipping containers were originally, delivered and put on the ground, and the town, informed us that they would need to be elevated and put onto trailers. So the town was very well aware of the trailer's existence.
And Mr. Houghton, when you appeared at the town council meeting in October of 2024, to the best of your recollection, do you remember discussing the configuration of the shipping containers as being on the trailers versus affixed to the ground?
Most definitely, they've always been on the trailers. In the evacuation video I did, we showed video footage of the trailers. Trailers are actually very visible from Estera Boulevard when you're coming over the bridge.
Thank you, Mr. Houghton. And I will also note, as Mr. Houghton just mentioned, the video that he is referencing showing the evacuation plan for these containers on the trailers, that is embedded in a hyperlink that was included in the town's letter to FEMA dated November 1st, 2024. So that is in the record, should you want to view that. I will also, I will just simply say I was not aware that there was a dispute as to the factual situation that these trailers were present. So I will let that be known on the record. We were also not aware that the town was unaware that the trailers were on site. Mr. Houghton, can you tell me a little bit can you elaborate on the evacuation that you did prior to Hurricane Milton, so we can have a better understanding of what happened there and how difficult or not difficult it was, and what kind of, whether that type of evacuation plan is easily repeated going forward?
Sure. Well, as you may have seen already, I prepared the evacuation video in September after getting word that the town was going to find me in violation because FEMA was coming down. So having done that, my team was ready to go, and the evacuation went very smoothly. It was just a matter of removing a little trim work. It prevents water from coming in between the two containers, but the two trailers just sit side by side, much like a boat would pull up to a dock. They can be easily backed in and removed from the 5-foot deck that wraps around to allow people to, and the ramping system that allows people to get up into shipping container bars and bathrooms. Everything's on quick disconnects, much like an RV, with the sewer and the electrical series of plugs that disconnect. All we have to do is remove the skirting from the front and hook on with a medium-duty pickup truck, preferably one with dually, dual tires on the back, that has a fifth wheel. So when we removed the shipping containers, we knew we had a period of time. The town had called for the evacuation order on a Sunday evening. We were pretty much ready to go, but we decided that we wanted to do it during daylight. So I let town staff and the mayor know that we would begin the evacuation the following morning. The gentleman that a friend of mine, Joe, J&E Excavating, that was driving the truck, decided that he wanted to haul both trailers himself. And since we had the time, he removed the first trailer around 7 a.m. and we towed it all the way downtown to a friend's property that was outside of any flood zones. And then he returned and hooked on to the other pickup, or the other trailer, excuse me. And the second trailer was removed around 11 a.m. There was extensive video footage of that occurring. and town staff was very well aware that we did remove those. All that was left for Hurricane Milton was the deck. So I'm not sure where the confusion is there with that, but by Saturday evening, we actually brought everything back to the island, and we were open for a short time. Yeah, that's it.
Thank you, Mr. Houghton. So to confirm, exactly how long did it take to remove both of these trailers from the site?
We took approximately 4 hours to do it once we commenced that morning. We could have done it even sooner had we just driven over the bridge, unhooked, and come back and yanked the other one out. We could have done it within an hour.
Thank you, Mr. Houghton. I believe, actually, Mr. Houghton, one more thing. Can you tell us about approximately how many employees you have and independent contractors and other folks who rely on DOAH for some or all of their livelihood?
Yeah, TEH4 Inc., which is my corporation, approximately employs 21 to 25 employees. Some are full, some are part-time. And then we have a whole host of entertainers that have been working with, that are 1099 employees, that have been working with me for years now. That we feature live music twice daily through most of the year. I've got a full season of entertainment bookings booked out. This is very important to me, but to all of them as well. So, thank you.
Thank you, Mr. Houghton. That's all that I have. I appreciate your candor.
All right, cross-examination?
I just have a few questions. Mr. Houghton, go ahead. I don't want to step in front of you. You mentioned that you did get a permit, and when was that permit issued to you to use the trucks and do things? Was it after Hurricane Ian?
The temporary use permit. Okay, so we received a few permits. The first one would have been for the food truck, which was shortly after.
Which is not an issue.
Okay. So I believe the other permit for the use of the shipping containers was held up until we were able to buy the trailers, crane the shipping containers on top of them, and then build the deck. So first, the town permitted the deck building permit, and then issued the temporary use permit for the shipping containers.
Okay, I don't know that you really answered my question,
So
so
the
I'm going to
date-
ask it this way. Was it prior to July 19th of 2020?
Yes,
And you mentioned that this was a heavy-duty trailer, not a light-duty one, is that correct? Could you give us more specifications regarding the trailer?
okay. So I think heavy duty was referring to the pickup truck. So the trailers are 40-foot gooseneck trailers, and the 40-foot shipping containers sitting on top of them. So there's two separate trailers, both with 40-foot shipping containers sitting on them. They're sitting right next to each other. They have a hitch on the front of them that needs a fifth wheel in order to be pulled away. So any pickup with the fifth wheel, with the correct amount of ton weight, would be able to haul them away. I believe anything bigger than an F-250, F-350 with dual tires on the back would be ample to do so. And that's what we actually used. We used two different trucks separate. I think we used an F-450 to pull them away originally, and then an F-350 to bring them back.
Okay, and I think you testified that it was approximately 4 hours for you to remove the structure and the non-compliant structure and come into compliance. Is that correct?
Yes, I believe we started, the first shipping container trailer was removed around 7 a.m. and the second one left the property around 11 a.m. that morning.
that was roughly what time frame? That was in anticipation of the, can you give me a date of when that happened? When you moved those trailers?
Well, it was the following morning after the evacuation order had been called for Hurricane Milton, it was a Monday morning after that evacuation order. I'm not sure.
Okay, so that was during the time frame when the town was on notice from FEMA that these items or vehicles are non-compliant structures, and you removed them from the site, and then you chose to come back to the site. Once you went into compliance, why did you then go back into non-compliance?
Well, we've always argued that we were not in non-compliance. Would be my answer to that. And,
I don't have any further questions.
All right, any redirect?
Just to confirm, so there was some question about the dates. It is my understanding that you removed those trailers the Monday before Hurricane Milton made landfall, correct?
Correct.
So if Hurricane Milton made landfall on Wednesday, October 9th, would it be safe to say that the date of removal would have been the morning of Monday, October 7th?
Yes, Monday, October 7th, 7 a.m. we commenced the evacuation and completed it by 11 a.m.
And that is all I have for him this time. Thank you.
All right, thank you, Ms. Hyman, thank you, Ms. Thibault. Do you have another witness?
Not at this time, but if you have any other questions for either Mr. Houghton or Mr. Primo, I'm sure they would both be ready, willing, and able to answer those.
All right, I don't think I have any further questions at this time. Does the town have any additional evidence to present?
Your Honor, we would like to have the opportunity to have our expert floodplain manager to discuss the day-to-day interpretations and applications of some of the CFR sections that Ms. Thibault argued about. If I may call Mr. Thomas back to the stand.
All right.
Thank you, Your Honor. I'll be brief. I think the primary challenge in this particular case in particular is it's kind of in that gray area between being a structure, trailer, recreational vehicle, some sort of hybrid in between, in terms of determining whether it's compliant in terms of meeting floodplain regulations. What we do know, it's not elevated, it's not anchored to remain in place during the flood event, and has no flood vents, no breakaway walls, so the water can't pass through the structure if they weren't able to remove it in time during a storm event. And the last issue with this particular case is in terms of the attachments to the structure. I know it was mentioned that there were some removal of trim work. I would just like to confirm that did not include any of the additional stairs or decks or porches that were adjacent to the structure, because in order to meet the requirements of a recreational vehicle, they would have to be completely detached.
Mr. Bruce, any other questions for Mr. Thomas?
Not for Mr. Thomas, however, I would like the opportunity to let Mr. Yazzo or Officer Yazzo make a few more comments.
Let me ask if Ms. Thibault has any further questions for Mr. Thomas.
Yes, just one quick question for you, Mr. Thomas. I'm sorry. Is it your opinion then that the minor trim work then is, I guess I'm just a little bit, I'm just seeking clarification on the distinction you were making between the trim work and the decking, because the decking was permitted as standalone, I believe, but the trim work is just separate, so.
It was more so a question in terms of confirmation that the deck and the stairs during the tear down process to remove the structure from the Hurricane Milton evacuation, did that include any detachment of the deck from the trailer, because it can't be attached in any way to that structure. So I just want a confirmation.
Thank you, Mr. Thomas. I appreciate it. Your Honor, Mr. Houghton is able to answer that question for Mr. Thomas.
I'll just go ahead and take that, and then we'll come back to the town for the other witness. Go ahead.
Yes, and we've actually got some video footage of this, but the trailers are not attached to the deck in any way. The deck is a permitted building structure separate from the trailers, and they are not attached.
What happens to the deck when you evacuate the container? It stays put?
The deck stayed in place, yes. Yeah. And the flood waters can flow underneath it, yes.
All right.
Okay.
All right, thank you, Mr.
Thank you.
Let me come back to Ms. Cooper. If you wanted to bring back the enforcement, the code officer?
Yes,
Your Honor, just to be clear, so we're clear on when this was posted. The 24th day of September is when the notice of violation was posted to the property. They left on October 7th through the hurricane and came back sometime thereafter. I do get that it was answered that they don't feel like the violation is appropriately put forward to them, but they did come back after they knew that they were already violated within the compliance.
Anything else?
That would be it, Your Honor.
Ms. Cooper, any questions? Officer Yazzo?
no, Your Honor.
Any cross-examination, anything else that you have, Ms. Tebow?
Just one final point to Mr. Yazzo's point, as far as the timing with the NOV being posted on September 24th, 2024, and the subsequent evacuation about 2 weeks later. Simply getting a notice of violation does not mean that you are actually in violation. And as you've seen today, the property owner and the operator, the respondents jointly, are of the belief, as am I, that there is no violation here. So I would like the comment that, it was removed and brought back when they knew it wasn't in compliance to be stricken from the record, because that's not the case. There's clearly a legal dispute here as to whether a violation does exist or not. Thank you, Your Honor.
I will strike it from the record, but I'll take your argument on the point and assess that testimony, in light of all the evidence. In regard to the other evidence, does either side have anything else to present in terms of any witnesses that you want to call? I know we have some exhibits, but any other witnesses?
No, Your Honor.
Ms. Tebow, anything else?
No, Your Honor. Thank you.
And I have the town's exhibit package, which I'll receive in evidence. Ms. Tebow, you referenced at least a photograph of the trailers. Was there anything else that the respondents wanted to offer?
Everything that we would like to offer, aside from the presentation that we provided, including the photos of the trailer, have been submitted by the town already in the record. And we are, of course, very appreciative of the town for providing such detailed exhibits.
All right, well, I'll go ahead then and receive those exhibits as well. I know there's some dispute potentially about the trailer. I've got some testimony about that. In addition to the photograph. Let me do this. Is there anything else that the parties, we've had some extensive argument, anything else the parties want to say by way of closing? Ms. Cooper, is there anything else you wanted to add?
Not as far as argument, Your Honor. However, we did provide in the packet to you a draft order, which I've given a print copy to Ms. Thibault. The only addition we would add is what we're asking for is the fee of the administrative charge of $250.
That would be to cover your cost of prosecution?
Yes, sir.
All right, here's what I'd like to do on this one, because there's been some extensive argument and there's a legal position that the respondents are taking, that gets a little bit involved in these definitions. I'd like to give the parties an opportunity to submit their arguments in writing if they'd like to do that. Is that something that either or both parties would like to do? I'd give you like a week if you wanted to file a memorandum that I could look at as well. But it's up to you. I'm not going to require you to do it. If you do want to do it, I'll give you that opportunity.
Your Honor, respondents would be open to that and would very much like to submit their arguments in writing as well. Thank you for the opportunity.
Would the town like to do that?
Yes, we'll be responding to them. If we could have perhaps a week after they submit, would that be okay? I don't know if their arguments are going to go beyond what was in their presentation.
That's fine with me too. I obviously want to keep things moving, but Ms. Tebow, is a week enough time for you to get something in?
Your Honor, I appreciate you asking. I would actually, I have a fairly busy hearing schedule between now and next Tuesday. If I was afforded 10 days, potentially to Friday the 17th, that would be much easier for me if that would work for you. But of course, I will defer to you ultimately on whatever you decide, Your Honor.
If you had until the 17th and the town had to the 24th, does the town have any objection to that?
No, Your Honor. If you're also intending perhaps to continue this matter to the 4th, we could then address the arguments there.
Well, I could do that as well. What I had really contemplated doing was just taking the memoranda, so I'd have those as well to look at. You know, you'd have a chance to develop your arguments in line. I'd go ahead and get the order issued, which I could probably do before the 4th.
That would be fine.
If you'd rather do it that way. I'm not sure I need to have you come back, although I can. I mean, I'm open to that as well. I think I'm going to be able to rule once I get the memos that, I've got the exhibits, I've heard the testimony. It's really not so much a fact dispute here as a legal one, which is why the memos might be helpful.
The memoranda would be fine.
Yeah.
Thank you, Your Honor.
All right, so respondent said you'll submit, you would file it with the Division of Administrative Hearings, your memorandum by the 17th of this month, and then the town will file a response by the 24th, and I'll wait to prepare the order and issue the order until after I've received both of those memoranda. I understand the town has submitted a proposed order, and Ms. Tebow, if you want to submit a proposed order as well, you can do that with the memorandum. Again, it's up to you. But whatever you all submit, I'll review in connection or in conjunction with the exhibits and the testimony I received, and I'll get your final order out probably before the 4th of next month. It shouldn't take too long to get the order out once I've got the memos, but I would like to take a look at those.
Thank you, Your Honor. Thank you.
All right, anything else on this case then? All right, so just to wrap up then, to summarize, I'll take this matter under advisement pending receipt of the parties' respective memorandums of law. I have the exhibits that have been filed, obviously the testimony I received today, and I will reserve ruling until I've gotten the memos. After that, I will put together the order and get that issued, hopefully before the end of the month, before next hearing. All right. If there's nothing further on this case, we can move on to the next one.
Thank you, Your Honor. The second case for your review today is regarding the violations of the town's floodplain codes. Is Fort Myers Beach case number 2024-0914. This was filed as the DOAH case 24-004834. It was filed on December the 19th. This involves property at 1821 Estero Boulevard. As in the prior case, just to put into the record, I'd like to just make a few preliminary remarks regarding the nature of the complaint that precipitated. My comments are tied to the documents that are in Exhibit A. Having Exhibit A as part of the record, I'll try to summarize as quickly as possible. Exhibit A does contain a letter from FEMA dated July the 19th, addressed to Andy Hyatt as the town manager of the town of Fort Myers Beach. Attached to the letter is a summary regarding compliance with codes, specifically on page 3, paren 2B, requires the town to provide a plan for remedying any identified violations in that letter. And attached to that letter is a more detailed report specifying that one of the violations is the failure in the town's permitting system to allow the use of temporary non-compliant structures, including shipping containers and trailers / food trucks. The statement in FEMA's letter was followed by a list of citations of the Town of Fort Myers Beach Code of Ordinances, specifically also stating that non-compliant structures and temporary structures have been placed in the coastal high hazard area, the VE zone and coastal A zone, requesting that the town provide a plan to remove these or bring them, the non-compliant structures or non-compliant additions, into compliance, and confirming that the town has stopped issuing permits for this type of development. The town was placed under a deadline of November the 19th. I'm not sure if it's the 19th or the 18th, but it's in the letter, for the town to remedy the matters. And then the town council directed the town manager to stop issuing these permits. These temporary permits were issued immediately after Hurricane Ian devastated the island to try to create some type of semblance of a town. And so because of the benefits that these businesses did provide immediately after Hurricane Ian and continue to provide as the town goes through its rebuilding process, the town sent a letter to FEMA asking for an extension of its compliance date to June of 2025. Attached to that was a video showing how quickly some shipping containers can be removed from properties in the event of a declaration of a hurricane warning. FEMA responded that they're not authorized to extend the period of time, and went on to say that the purpose of these regulations is the protection of lives and property that is located in the special flood hazard area. That these non-compliant structures are the most at risk in the VE zone, also known as the coastal high hazard area, which did receive a 14-foot storm surge during Hurricane Ian. And allowing these structures to remain in place presents a hazard to the residents and businesses in light of another storm, as was demonstrated by Hurricane Helene and Milton. So again, some of these non-compliant structures have been removed voluntarily. On December 16th, the town directed the town manager to rescind any remaining temporary use permits that had been issued in the aftermath of Hurricane Ian. And the town continues to work with property owners who do have, in the town's opinion, non-compliant structures on their property to have them removed voluntarily. However, we haven't been successful in some situations, and unfortunately, we've had to bring these matters to you. We ask that you accept the exhibits that are attached to the hearing exhibit packet provided to you into the record. And also attached there are documents from the town clerk evidencing the revocation of the outstanding permits. So in this case, as in the other cases, you'll be hearing testimony from Officer Thomas Yazzo and our floodplain manager, Carl Thomas, and they will each introduce themselves and state their qualifications regarding this matter. So I defer at this time to Officer Yazzo.
Good morning, Your Honor. Again, my name is Officer Thomas Yazzo. I'm a code compliance officer and a compliance security manager with the town of Fort Myers Beach. As the manager of the Compliance Security Department, I'm responsible for the day-to-day operation of the Town of Fort Myers Beach Code Enforcement Department, and I supervise 4 code officers. I review all code enforcement cases with them and have access to all available code enforcement files. In addition, since July of 2024, I've also personally been involved with the town's efforts to come into compliance with the floodplain regulation deficiencies identified by FEMA, which are incorporated into the town's code of ordinances. I have been sworn in and will provide testimony and documentation regarding the violation in this case. During my testimony, I will periodically refer to the exhibits in the agenda materials. I request that these materials be admitted into evidence and included as part of the record for this case. Again, this is a Fort Myers Beach Code Enforcement case number 2024-0914, which is also identified as DOAH case number 24-004834. The subject property is located at 1821 Estero Boulevard, Fort Myers Beach, Florida 33931. On September 19, 2024, I observed 3 shipping containers on the subject property, which I determined to be a non-compliant structure based on the current floodplain regulations, inclusive of design codes required in special hazard areas as defined in Section 6-494 of the Fort Myers Beach Code of Ordinances. The subject property is partially located in the coastal A zone as identified in the latest floodplain map and requires the structures to have a base flood elevation of 13 feet above sea level. I observed that the shipping containers were not elevated to the best of my knowledge and do not have engineered plans for pilings or infrastructure. They also have no visible chassis or steering axles attached to the structures. I then consulted with the Fort Myers Beach floodplain manager, Carl Thomas, who confirmed to me that the shipping containers on the subject property were non-compliant structures based upon my observations and a violation of Section 6-501 and 6-525 of the Town Code of Ordinances and the American Society of Civil Engineers ASCE 24-14, which is incorporated by reference into the town's codes. My review in consultation with Mr. Thomas is consistent with FEMA's determination contained in their letter of July 19, 2024 and November 12, 2024. I prepared a notice of violation. A copy of that notice of violation is included in Exhibit B. I searched Lee County Property Appraiser's database records containing property owner information and further verified that the property owner is 1821 Estero Boulevard Corporation based on a deed found in the official records of Lee County, Florida. I issued the notice of violation on September 24th, 2024, and sent a copy of it by certified mail return receipt to the address of record, specifically 705 10th Street, South, number 305, Naples, Florida, 34102. Posted a copy of the notice of violation at the subject property and at the town hall located at 2731 Oak Street, Fort Myers Beach, Florida 33931. I have an affidavit of mailing and posting of the notice of violation. I would like to also include the record. Notice of and the information about the case is also displayed on the Town of Fort Myers Beach website under public notices. I believe that the respondents are present today for this hearing. I also took photographs to document the violation I observed on September 19th, 2024 in Exhibit C. They contain true and accurate and unaltered copies of these photographs during my initial inspection of September 19th, 2024. Photographs show the shipping containers are not elevated 13 feet above sea level. They do not appear to have any visible chassis or steering axles, so they're not easily removed from the island with a light-duty truck. That's also in Exhibit B. The additional photographs I took showed posting the notice violation, subject property on October 2nd, and posting the notice at Town Hall on October 2nd with an affidavit of notice and posting. In my notice of violation, I gave 1821 Estero Boulevard Corporation 30 days from October 2nd, 2024 to remove the shipping containers from the property or to otherwise come into compliance with town codes. I directed a re-inspection of the subject property to occur on December 10th, 2024 by Officer Marcio Chavez, who I supervise and is one of my officers. He informed me that the shipping container remained in the subject property in the same condition as shown on the photographs I previously took and which were a part of the case file. I directed Officer Chavez to prepare an affidavit of noncompliance, a copy of which is included in Exhibit D in the agenda materials. The property owner received a letter revoking and rescinding his permit on December 18th, I believe, 2024. Excuse me, Your Honor, I defer to my records here for a second. December 19th, 2024, a copy of which is included in Exhibit F of agenda materials. As a result of the property owner's failure to remove the shipping containers or to bring the subject property into compliance with Section 6-501 and 6-525 of the Town's Land Development Code as identified in the notice of violation, the property owner was provided with a notice of today's code enforcement hearing as shown in Exhibit G, a copy of which is being presented at today's hearing. In advance of today's hearing, I inspected the property yesterday, January 6, 2025, and took photographs of the shipping containers with floodplain manager Carl Thomas present, which remains on the subject property in the same condition as I initially observed on September 19, 2024. I would like to add those photographs to the record as Exhibit H. At this time, Your Honor, I would like to ask floodplain manager Carl Thomas to provide you with additional information regarding the town's code sections and ASCE 24-14 and what is needed for a shipping container to attain compliance with the town's code. Thank you, Your Honor.
Let me, before we take the next witness, let me ask who's here on behalf of the respondent?
The landowner, property owner, and
Yeah.
Let me just see who,
You can.
are you here for the respondent?
morning, Your Honor. Yes, I'm the property owner,
Okay, and what's your name?
Gordon Stojkowski.
Say that again, please.
Gordon Stojkowski, Stojkoski, on behalf of 1821 Estero Boulevard Incorporated.
Okay, Stojkoski.
Yes, sir.
All right. You're the property owner. Do you have anyone else here with you?
The tenant.
Okay. Did you have any questions for Officer Yazzo before we take the next witness?
I do not.
All right. Let's go ahead then and hear from Mr. Thomas.
Good morning again, Your Honor. Again, my name is Carl Thomas, and I'm the floodplain manager for the town of Fort Myers Beach. I've been a floodplain administrator since 2011 and received my certification in 2011 as well. With this certification, I've worked with several local governments concerning floodplain regulations such as those in effect in the town of Fort Myers Beach. Since May of 2024, I've been specifically working with town staff and representatives, along with representatives from the Federal Emergency Management Agency to meet the requirements of FEMA's post-disaster compliance report for Hurricane Ian, included in Exhibit A of the agenda materials. I'm here to provide testimony regarding the non-compliance of the subject property, which is located in a high-risk flood zone. In September of 2024, I had conversations with Officer Yazzo regarding his concerns that the shipping containers on the subject property were in violation of the town's floodplain regulations as claimed by FEMA in its compliance report. I explained the criteria that would need to be satisfied for compliance with Chapter 6, Division 10, Sections 6-501 and 6-525 of the town's Land Development Code. A copy of the code is in an excerpt of ASCE 24-14 are included in Exhibit E of the agenda. In short, I explained to Officer Yazzo that Sections 6-501 states any structures located in the flood zone, even if they exempt from permitting per Florida Building Code, must be designed in accordance with the American Society of Civil Engineers, ASCE for short, standard 24-14 for flood resistant design and construction, where compliance includes elevating the structure to a base flood elevation plus 1 foot, anchoring the structure to remain in place during flood conditions, or having flood openings or breakaway walls that allow unobstructed passage of flood waters through the structure. Noncompliance with flood regulations not only increases the vulnerability of the structure, but also poses significant risk to public safety, neighboring properties, and the environment. Additionally, it jeopardizes the community's participation in the National Flood Insurance Program and potentially increasing insurance premiums for all its policyholders. Subsequent to the September conversations with Officer Yazo, I accompanied him on the site visit to the subject property during the second week of December, and most recently, a follow-up site visit on yesterday, January 6, 2025. On those visits, we discussed the requirements of the town's compliance to meet the floodplain regulations. For purposes of illustration of the hazard non-compliant structures can cause, I have a photograph I received from Officer Yazo taken after Hurricane Milton by Jeffrey Hope, showing evidence of a non-compliant structure that was displaced and created a hazard to the residents of the town. In my opinion, similar displacement is possible with non-compliant structures such as the subject property, depending on the strength of the flood event. In summary, it is my opinion that the shipping containers located on the subject property are non-compliant with the cited town floodplain ordinances, and I would like to ask the judge to include a copy of ASCE 2414 and Mr. Hyde's photograph and record for this case. Mr. Hogue, I apologize. Mr. Hogue's photograph and record for this case.
All right, Ms. Stupovich, do you have any additional questions for Mr. Thomas?
Not at this time, Your Honor.
All right, does the respondent have any cross-examination, any questions for Mr. Thomas?
No, Your Honor.
All right, does the town have any other evidence to present at this time?
No, Your Honor. Just again, we've provided a draft order to you. We're pretty much asking for the finding of violation of the noted section 6-501, 6-525 ASCE 24-14 as of, again, emphasis on January the 6th, based on the most recent photographs that have been taken, requiring a reasonable or requesting a reasonable period of time by you to be identified as a compliance date, and the imposition of a $250 day fine for each day the violation extends beyond your compliance date, an administrative fee of $250, and authorizing the town to abate the violation if the shipping container is not removed or coming into compliance by March the 1st, with any expenses to be paid by the property owner within 30 days. If not paid, the town would come back to you requesting certification of the amount owed to be imposed as a lien on the property.
All right, very good. Let me come back into the respondent. You may present your case.
Thank you, Your Honor. As the landowner and business owner of the property before the storm, I had a very successful restaurant there that employed about 40 full-time employees. Obviously, the storm wiped us out completely, wiped out a family home that was also behind the restaurant. So after the storm, everyone was trying to see what we could do to pick up the pieces and how to recuperate and move forward with life on Fort Myers Beach. So with that said and done, Steve had a bicycle rental business on the island that was in the same situation that most of the business people were in the area. Lost his structure, completely wiped him out. So he approached me to see if I was up to the idea of leasing the outdoor parking lot space that we have to see if he can somehow, some way try to recuperate and open up his business. Wonderful idea. I think that Fort Myers Beach also thought it was a wonderful idea to have a small business willing to take the risk to reopen right after a catastrophe and service the people of Fort Myers Beach. without people like myself, let's say, and Steve that are willing to take the risk to reopen something that was devastated without any guarantee what the future may behold. The city's stance is that they issued permits on error. Well, that's very easy to say. Well, you issue a permit and then the business person takes out a loan because he got wiped out to move forward and rebuild and invest and buy these trailers that were approved by the city that issued the permit. They specified what kind of trailers they needed to be, with axles, with tires, so that they could be moved if need be, let's say within a few hour notice, which Steve has done. And there are, under Exhibit H, the pictures that they have are actually great pictures. So these are cargo containers that already have the axles and trailers on them. Mr. Steve feels confident that if he needed to remove these in an emergency situation with 3 tractor trailer trucks, they could be removed within an hour, let's say. So permits that were issued, investments were made, trailers were purchased, or cargo containers were purchased specifically to comply with the permit, so that he can open up this small business to service the city of Fort Myers Beach. So that's where we're at. My question to the city is, to the attorney, to see whether they could answer this: if FEMA didn't get involved, would these trailers be compliant? These cargo containers that were originally approved by the city and permits were by error issued. So without FEMA strong arming the city, the question is, are these trailers non-compliant?
That might be a question that would have been best addressed to say someone like Mr. Thomas. But I don't have an answer for you on that one. But just so I'm clear, you're saying that you received a permit in the wake of the Hurricane Ian, I guess, to place the containers. That permit was something that we revoked at some time?
Correct. So the permit was issued specifically to purchase these containers and the containers to have the capacity to be moved on a short notice. So these containers, again, under Exhibit H, you can see that they have axles and tires. So all they need to do is be hooked up to a tractor trailer and they could be removed within 1 hour, let's say. So that's the permit that was issued, and that's what was purchased. Again, in an extensive investment that loans were taken out to get this business reopened. And I just don't see how the city can just revoke a permit because FEMA is strong arming them and then using the FEMA as an excuse to have them, these structures that they approved, be non-compliant. So my question to the city or to Mr. Thompson is, if FEMA wasn't involved, are these containers that have the capacity to be moved non-compliant?
You're saying that the permit was revoked?
It was revoked a month ago, not even. So the permit was revoked a few weeks ago, Your Honor. And I'm assuming that the permit was revoked in retaliation for the assumption that these containers were non-compliant. Again, nothing was proved because the city says they're non-compliant because FEMA is telling them they're non-compliant. I mean, I'm just curious to see what the city thinks, that if FEMA wasn't involved, whether these containers are compliant or non-compliant.
You think that would make a difference?
Well, I think it would definitely make a difference. I mean, if they're non-compliant, why would they issue the permit and have them specifically tell the business owner that he has to purchase these and this is what is requested? Again, I'm the property owner, and we've lost an extremely amount of resources here, and we're grasping on a string to survive here. The town wants small businesses to come back, and then you have a small business that invested everything all over again, and then you're trying to destroy somebody just because FEMA thinks that these containers are non-compliant. That's the whole question here. Unless
I
I'm,
guess my point was, and we can hear more from the town about this as well, is just as a.
I mean, if they're non-compliant,
From a legal
what?
standpoint,
Yes.
let's assume, suppose FEMA is correct, and I'm not saying at the moment they are correct or not correct, but suppose FEMA is correct that the structure is not compliant. And FEMA brings that to the attention of the town, which had previously issued a permit. The town decides the permit was issued in error and revokes the permit. Does it matter if the town originally thought it was okay and then was persuaded otherwise by FEMA? Maybe that matters, or maybe it doesn't. That's what I'm asking.
Right. I mean, I think it matters because obviously, again, on issuing of a permit, I mean, whether it's this business or any other business, if you issue a permit, then that person that receives that permit invests not only money, it's a lot involved, especially in the summertime on the beach where it's extremely slow, desolate, let's say, and you have a business owner struggling to pay the bills, to pay the rent, to pay employees, to survive, to wait for November, December to come around, which isn't spectacular anyways, because why would somebody want to come to Fort Myers Beach right now when there's only a few restaurants left? So you're trying to eliminate a few of the other businesses that are here now. It just doesn't make any sense. It's like, what are we trying to accomplish here?
Right, I was just trying to get a
Yeah.
sense of the nature of the argument that you're making.
I mean, if
I
the
think as a
city,
general proposition, you're right. I mean, if the authorities issue a permit, usually that permit, should stand. If the authorities decide it was issued in error and revoke it, that's not the usual course of events. On the other hand, if it truly was issued in error, does the authority have to propagate the error and let it last? I don't actually know the answer to that question off the top of my head. I'm just raising it. That's
Right.
obviously perhaps the key point that you're making, if I understand your position, that the permit having been issued should be honored now. That's what you're saying?
correct. If the permit was never issued to begin with, the expenses would have never been occurred to purchase these structures that were conforming and permitted 2 years ago or a year and a half ago. So now, because FEMA is revoking the insurance benefits on the island, which I completely understand, but there has to be some kind of solution for the small business owner that's invested hundreds of thousands of dollars in loans to buy these structures, to place them on a property and invest to for the future of the island. And all of a sudden now you just want to revoke the permit and tell them you have to move your structures in a certain amount of time. I mean, I don't see how the justice or the fairness in that is either.
Right. Okay. I understand the argument that you're making. Did you have anything else you wanted to present? Any other evidence or witnesses?
Yes, Your Honor. My name is Steve Larson, and I'm the operator of the business, the co-owner. The corporation is MADL LLC, doing business as Sun and Fun Sport Rentals. So, as Gordon said, based on the permit that we received from the city, which we received after extensive meetings with a lot of people at the town, submitted drawings and everything, they issued the permit. And then we subsequently invested, it is hundreds of thousands of dollars, not for these structures, but for the equipment that we rent. We rent golf carts, bicycles, scooters, amongst other things, e-bikes. So
And just to get the business going, it was several $100,000. So going out of business is not an option. All right. We also invested in making these containers look really nice. Okay. They're not just containers thrown, you can see by the pictures. So my request from this would be, I guess, first of all, I'd like to just keep the containers like they are, on wheels, on axles, able to move. But if not, I want clarity from the town on what I can do. And I also would like time to remove the containers, not during our busy season, which was mentioned in the previous case. So it would be a burden right now to have to deal with all this. In June, it wouldn't be such a burden. So that's my request.
What would you do to keep the business operational if the trailers were, if the containers were moved?
Well, that's what I have to discuss with the town. What can I put there? You know, the containers were, quite honestly, the containers were at the town's insistence because they wanted everything inside. They wanted nothing. They didn't want any bicycles outside or anything. So I ended up with 3 40-foot storage containers. I could do without that if we didn't have to have everything inside.
All right. Anything else, Mr. Larson?
No, sir.
Let me ask Ms. Cooper, do you have any cross-examination for either of the witnesses? We've got,
I do, Your Honor. Factually, I don't know which individual is more appropriate. So if either of them want to respond, that would be fine. I heard testimony that the non-compliant structures are movable. And the question I have was, did it move during Hurricane Helene or Hurricane Milton?
The answer to that is no.
Okay. And could you tell us a little bit more? Could you explain why?
Well, quite honestly, it was a logistics issue as far as getting somebody in there, probably poor planning. But as a backup plan, we opened the containers up and let them flood. So they did not move 1 inch.
And you show in the pictures depict that there are wheels on the non-compliant structure. When was the last time that non-compliant structure moved with those wheels?
It has never moved.
Are the wheels operational?
Yes.
But how did the container get there in the first place? Not with those wheels?
No, the container got there with a similar situation to what you were discussing in your last case. But then the axles and the wheels were put on after.
So it is your testimony that there is axles.
Yeah. It's the only way you can do it. The axle goes right into these holes on the side of the container.
Okay.
And they're very expensive, by the way.
Okay.
They have to be heavy duty.
I understand. That was my first set of questions. My second set of questions is that there was reference made to the permits that the town had issued in the aftermath of Hurricane Ian. Were there any conditions that were placed on your permit? I don't have a copy of your permit in the record.
Yes. To my recollection, they first of all had to be on wheels. And like I said, the equipment had to be inside. Those were the two things that I remember.
just so I'm clear, forgive me, I know there are some packets of documents and some that maybe have been recently sent to me, but is this a permit or emergency permit that was issued after the Hurricane Ian? That's not in the packet. That's not one of the exhibits.
Do not think so, Your Honor. What is in the packet is the letter of revocation of that permit. And I believe there's a copy of the code that requires a 180 days because it is a temporary permit. It's not anticipated that it would be a long-term permanent permission.
Well, that was gonna be my next question. I mean, it's referred to as a temporary emergency permit, so it had an expiration date essentially?
It did. There was, I believe the code requires that they come in within 180 days and request an extension. But that permit, again, I think it still is in the code of ordinances, but it has not been, no additional permits have been issued.
It was, at some point it was revoked, right? There's a letter of revocation, you said?
That is correct.
And
That
it
was-
was revoked on grounds of error or mistake on the town's part?
Yes,
Not, I mean, just so I'm clear, it wasn't revoked because of non-compliance with a permit condition.
it was not correct. The revocation letter, that was my next, is just to state for the record that that's really the correctness of the revocation letter, I don't think is the issue in this code enforcement case. Because there are other remedies administratively that those questions could be addressed.
Your Honor,
Go ahead, yes.
I can provide a copy of the permit and it had no expiration date.
Okay. But Ms. Cooper raises a valid point, however, about the remedies for, say, a wrongful termination of the revocation of the permit, and I'm not saying that it was, improperly revoked or not at the moment, just in terms of remedies for that situation, I'm not sure that the code enforcement proceeding is the place to do that. Has the respondent taken any action to dispute or challenge the revocation notice? And it may be the time to use it hasn't even run, but
Yep.
just actually, anything's been done.
We have not, Your Honor.
Okay.
We decided to come to this hearing.
So, Your Honor, in the record, attached is a copy of, a certified copy of resolution number 24-296. And one of the whereas clauses in that document states, whereas both ordinances referring to the emergency temporary placement permit and the temporary placement permit, because they changed the name a little bit, provided that permits issued under either ordinance would be issued in increments of 6 months and would not exceed 18 months without demonstration of a hardship. So it was always anticipated by the town in the adoption of that ordinance immediately or shortly thereafter Hurricane Ian, and then the town made some amendments to it that these were temporary and not permanent.
Okay. All right, and Mr. Super, do you have any further questions for with the respondent witnesses?
I don't, Your Honor. Thank you.
And does the town have any additional evidence to present?
I would just ask if Officer Yazo or our floodplain administrator Thomas, if they wanted to have any last comments. I'm seeing them saying no. So we rest.
All right, so I have the initial testimony, I've got the town's exhibit packet, which I'll receive in evidence. Did the respondent have any documents to present? Apart from what the town already has?
Your Honor, the only thing I can think of is the actual permit, which you have not seen yet, that has no expiration date on it. I just don't have it with me right now.
All right. Is that something that you wanted to submit?
Yes, Your Honor, I would like to.
All right, well, I'll take a look at it and I'll submit that, I'll see that evidence as well. Again, without a moment commenting on the relevance, potential relevance, I do think that, the town may be correct that the remedy for the revocation might lie elsewhere, although, I can't say off the top of my head exactly what that remedy is or what, the town's code of ordinances provides in that respect. But it may be that, that particular decision needs to be challenged outside of this proceeding. But I'm happy to take a look at it. What I was going to do again, because the town has submitted a proposed order, I'm happy to let the respondent do the same. If you would like to do that, I won't require it, but did you want to submit a proposed order as well to compete with the town submission? So I'd have both to look at.
Can you clarify what you're talking about?
The town has submitted a proposed order, presumably it would find the violation that the town is seeking, and the other, remedies that have been outlined by Ms. Duperich, probably include some proposed findings. I'm saying that if you would like to do the same thing, I'll let you do that. If you wanted to submit a proposed order of your own, it would be not finding a violation. Again, I'm not going to require you to do that, but I'll give you the opportunity if you want.
I don't think so, Your Honor.
All right. All right, and if you want to submit that permit, file that with Division of Administrative Hearings, can you do that by the end of the week?
Yes, Your Honor.
All right.
It's a little out of sequence, Your Honor, but I think Officer Yaza did want to ask one more question.
Okay.
Your Honor, I would just ask if the respondent, because I can't tell and I'm not an engineer nor a mechanic for the wheels. I don't dispute their claim that they're working steerable axles, but I wouldn't ask them to show proof of that. That would help us a long way in going towards them being able to remove those items quickly as they say they can. So if they could show some type of proof within their return that those are steerable axles, that they have some type of engineered report or mechanics report or something that gives us that we can substantiate within the case.
Well, let me ask the respondent, is that something you can provide to Officer Yazza?
Your Honor. Well, the question would be then, if those axles are operational, would we be conforming? So if those containers, again, that were permitted, that the town insisted on having those specific containers with those specific axles on them, if they are proven that they can be removed, the containers, would we be compliant?
So the answer to that would be that that is one part of compliance. There are several sections that have to go with everything from elevation to mitigating hydroventing and such. So that would be one part. I'm going to defer to floodplain manager Thomas.
Just to clarify, if these structures are deemed highway ready, licensed and highway ready, that they're able to be removed off site during the event of a flood event, then that would be the only requirement for them.
Say that again, if they were licensed, in other words, if it were more like an RV, you're saying?
Yes, I mean, similar to the discussion that we had with the previous case, if we had, because based on the site evidence, it's hard to tell that the wheels and axles that were installed on the structure were quote unquote highway ready. If they could demonstrate that and they had the proper documentation to certify that, then it would not need to meet the flood resistant requirements because it would be able to be taken off site during the event of a storm.
Essentially, that's a compliance issue. I mean, if I find a violation and it's established a compliance date, and before that date, the respondent came forward with sufficient proof of highway readiness and the license and so forth, they might be able to establish compliance that way.
Correct.
Okay. All right, very good. Well, I will, Mr. Larson has indicated he wants to submit that permit. I'll take a look at that, with the other exhibits. You submit that to me by the end of the week, that's January 10th. I'll reserve ruling until I receive that. After that, I will get together, make a decision, get an order out. Probably shouldn't take too long to get the order out. But I will, I'll wait until I receive that, as well. Is there anything else that we need to do on this case? Anything from either side?
No, Your Honor.
All right, nothing further from the respondent?
No, Your Honor.
All right, very good. Thanks for coming in, gentlemen. You all are free to go.
Thank you.
Why don't we've got two more cases on today's agenda to hear. Before we hear the next one.